If you are not a U.S. citizen and you think one DUI is just a traffic mistake, stop right now. Because the way immigration enforcement works heading into 2026, one single arrest, one single guilty plea, one single night where you tell yourself, "I'm fine to drive," can put your entire life in America on a collision course with deportation. Green card holders, visa holders, and undocumented immigrants, I'm talking to you directly. Because the scariest part isn't the flashing lights in your mirror. It's what can happen quietly after that. When your fingerprints hit a database, when a routine application gets denied, when an officer decides you're now removable, and suddenly the country you've built your life in starts treating you like you're disposable. Here is the immediate direct point, clear and without hype. Yes, one DUI can lead to deportation for some non-citizens, but it is not automatic in every case, and it depends on the exact charge, the exact outcome, your status, your prior history, and the enforcement pathway that gets triggered. What changed in 2026 isn't some single brand new act of Congress that says one DUI equals deportation. It's that the enforcement environment has tightened, and USCIS itself has expanded when it will initiate removal proceedings by issuing a notice to appear, an NTA, the document that starts deportation court. Especially after denials and in cases involving arrests, charges, or convictions, and people are feeling the effect of that shift now as it rolls forward into 2026. Source: who is most at risk? Anyone who is already close to the edge, people who fall out of status, people applying for immigration benefits, people with prior arrests, people with older immigration violations, people with a DUI that has aggravating facts like injury, driving on a suspended license, repeat offenses, high BAC, drugs, or a plea deal that sounds harmless in criminal court but is radioactive in immigration court. And if you stay until the end, you'll understand exactly why one DUI that should have been manageable becomes the domino that knocks down everything: your job, your license, your ability to travel, your green card renewal, your citizenship dream, even your ability to get bond and come home to your kids while your case is pending. Now let's slow down and make the law make sense, because this is the part most immigrants don't understand. Immigration consequences don't start with deportation. They start with paperwork, definitions, and triggers, and you can lose years of your life because you didn't understand the difference between an arrest and a conviction. An arrest is when you're taken into custody or cited. It's the start of a criminal case, not proof you're guilty. But it still creates a record that shows up in fingerprint checks and background screens. And it can still cause immigration officers to ask questions, demand certified court dispositions, delay decisions, or refer your case for enforcement review. A conviction is what immigration law treats as a formal judgment of guilt. But here's where it gets dangerous. Immigration can treat certain withheld adjudication or plea outcomes as a conviction if there is a guilty plea, or nolo contender, or admission of facts. And the judge imposes any punishment, penalty, or restraint on liberty. So what a local defense attorney calls no conviction can still be a conviction for immigration purposes. Source: DUI versus DWI? Different states use different labels: DUI, DWI, OUI, OWI. Often they all mean impaired driving, and immigration doesn't care about the letters as much as it cares about the elements of the offense, the sentence, whether there was injury, whether there was a mental state like knowledge or recklessness, and whether it fits into immigration categories like crimes involving moral turpitude, aggravated felonies, controlled substance offenses, or public safety grounds. And I need you to hear this clearly. A simple, first-time DUI, by itself, often is not automatically classified as a crime involving moral turpitude, and often is not automatically an aggravated felony. But that does not mean it's safe, and it does not mean it can't put you into removal proceedings through other routes. Let's talk about crime involving moral turpitude, because immigrants hear that phrase and it sounds like moral judgment, like immigration is calling you a bad person. Legally, it's a category that generally requires some kind of guilty knowledge or morally reprehensible conduct, and a basic DUI, in many jurisdictions, doesn't require intent to harm. It's more like a strict liability or negligence type offense, so it frequently does not qualify as a CIMT. But the moment the DUI is aggravated, the analysis can flip. For example, the Board of Immigration Appeals has held that an aggravated DUI under Arizona law where the person drives under the influence while knowingly driving on a suspended, canceled, revoked, or restricted license, can be treated as a crime involving moral turpitude because of that knowing factor, that conscious decision to drive when you know you're prohibited. Source. Now, aggravated felony is the phrase that terrifies people because it can lead to mandatory detention and wipe out forms of relief. But here's the truth. DUI is not automatically an aggravated felony, and the U.S. Supreme Court has made clear that DUI offenses that do not have a sufficient intent component typically are not crimes of violence under 18 U.S.C. Section 16, which matters because certain crimes of violence, with a sentence of at least a year, can be treated as aggravated felonies under immigration law. Source. That Supreme Court case is Leocal v. Ashcroft, and it's important because it shows how the legal category works. DUI causing serious bodily injury under a statute without a mens rea requirement was not automatically a crime of violence for aggravated felony purposes, meaning the law is more technical than the rumors online, and that technicality can save someone in one case and destroy someone in another, depending on the exact statute and plea. Source. So when people say, in 2026, one DUI gets you deported, the accurate translation is this. In 2026, one DUI can be enough to trigger the machinery that leads to deportation, especially when it collides with the newer enforcement posture, benefit denials, status problems, aggravating factors, or repeat history. Now, this is where families get blindsided. Removal proceedings don't only start because ICE randomly targets you. They can start because a government agency decides to issue an NTA, your charging document, and that can happen in more situations than people realize. USCIS, not just ICE, has authority to issue NTAs, and the USCIS Policy Memorandum updated February 28, 2025, explicitly states that USCIS is updating its NTA policy and will no longer exempt classes or categories of removable aliens from potential enforcement. And it describes criminal cases where, subject to referral processes, USCIS will issue an NTA against removable aliens who have been arrested, charged, or convicted if the benefit request is denied or withdrawn, as long as the person is not subject to mandatory detention under INA 236C. Source. That's the 2026 angle everyone is feeling. More immigrants are filing something. Renewal, adjustment, change of status, naturalization, a petition, a waiver, while carrying a DUI arrest or conviction in their background. And if that filing goes wrong, the consequences can be bigger than just denied, because denial can become a handoff into removal proceedings. And you might be thinking, but my DUI is old, or, but it was dismissed, or, but it's just one. Listen carefully. Even one alcohol-related driving incident can ripple into immigration through health-related inadmissibility screens, not just criminal categories. USCIS policy guidance explains that officers often encounter DUI, DWI arrests, and convictions in fingerprint checks, and those records may be evidence relevant to health-related inadmissibility because alcohol use disorder can be treated as a physical or mental disorder, and operating a motor vehicle under the influence of alcohol is clearly an associated harmful behavior that poses a threat. And USCIS guidance describes when officers may require re-examination by a civil surgeon, including scenarios such as one arrest, conviction for alcohol-related driving incidents within the preceding 5 years, as part of what it calls a significant criminal record for these purposes. Source. Here's where it gets dangerous. If you're applying for a green card or certain benefits, and you trigger a medical re-exam, and the civil surgeon finds a Class A condition tied to harmful behavior and alcohol use disorder, that can make you inadmissible, and if the case is denied and you're not lawfully present, you have now stepped into the lane where an NTA becomes a real possibility. Source. Now let me turn up the real-world pressure, because paper rules are one thing, but enforcement is where people's lives get shattered. ICE doesn't operate in a vacuum. Local systems feed it. Partnerships and information sharing mean that a local stop can become a federal immigration issue, especially in jurisdictions working closely with ICE. ICE's own description of the 287G program explains that under the task force model, trained local officers can enforce limited immigration authority while performing routine police duties, including identifying a non-citizen at a DUI checkpoint and sharing information directly with ICE so an ICE supervisor determines next steps. Source. So picture this, because this is how it happens in real life. You're a lawful permanent resident. You've had your green card for 8 years. You have a mortgage. You have a U.S. citizen spouse. You have kids who only know this country as home. You go out to dinner. You have 2 drinks. You swear you feel normal. You drive. And then you see the lights. You're polite. You're terrified. You're doing the test on the side of the road while cars pass by. And in your head, you're thinking, please, just let me go home. Maybe you get arrested. Maybe you get booked. Maybe you spend the night in jail. And you call your family at 3 a.m. and you can hear your partner trying not to cry. In the morning, you tell yourself, I'll handle the DUI case. I'll pay the fines. I'll do the classes. It'll be okay. But what you don't see is the second track forming under your feet. Fingerprints, records, databases, possible ICE awareness depending on the jurisdiction and your profile, and then later, when you apply to renew your green card, or you travel and come back through an airport, or you apply for citizenship, this incident resurfaces, and it's no longer one night. It's a permanent scar that the government can interpret in the harshest light if your paperwork or history gives them an opening. Now imagine you're an H-1B worker. You've built your career here. Your employer sponsors you. Your whole family's stability depends on your status. You get pulled over after a work happy hour, and the officer decides to arrest you for DUI. Here's the part most immigrants don't understand. Even before a conviction, an arrest can create chaos. Your employer may find out, travel becomes risky, visa stamping abroad becomes a gamble, and if you lose your job later and fall out of status while that DUI is on your record, a future immigration filing that gets denied can place you inside the zone where USCIS may issue an NTA if you are removable and not lawfully present. Source. Now picture an F1 student. One mistake, one party, one ride home you didn't plan, and now you're in criminal court. You think, I'll take a quick plea and be done, because you're scared and you want it to go away. But here's where it gets dangerous. The quick plea might be the thing that locks in a conviction definition for immigration. And later, when you try to change status or apply for OPT extensions or a green card, you discover the government isn't just judging whether you paid your fine. It's judging whether you're admissible, whether you have evidence of alcohol misuse that triggers medical review, and whether your record now invites deeper scrutiny. Source. And now let's talk about undocumented immigrants, because people love to pretend DUI is only a problem if you have papers. But for undocumented families, the risk can feel even more immediate. A DUI arrest can lead to extended jail time, and depending on local cooperation practices, it can increase the chance that ICE finds you before you ever get back home. And even if you do get out, it can complicate any future attempt to get status because the government will examine your record through multiple lenses: criminal, medical, discretionary, and credibility. Here's another brutal place this shows up: citizenship. People think naturalization is a celebration, and it should be, but USCIS can deny citizenship on good moral character grounds, and DUI history can matter. USCIS guidance states that evidence of 2 or more DUI convictions during the statutory period creates a rebuttable presumption that the person lacks good moral character, meaning you start the process already fighting uphill, and proving you're reformed after the fact is not automatically enough to show you had good moral character during the period when the DUIs happened. Source. Even with a single DUI, you can still face difficult questioning about rehabilitation, compliance with probation, honesty, alcohol use, and whether you meet the standard. And if the government finds other problems, like you were inadmissible at the time you got your green card, or you have a deportability ground, they may connect that naturalization filing to NTA issuance under their policy framework. Source. Now, why does it feel stricter in 2026, even if the statutory text didn't suddenly change overnight? Because enforcement is not just statutes, it's agency policy, priorities, and workflow. When USCIS openly states it is strengthening the integrity of the system through enforcement, narrowing broad exemptions, and expanding circumstances for initiating removal proceedings through NTAs, the lived experience for immigrants is that routine contact with the government has sharper edges, less forgiveness, and higher stakes. Source. That's why you're hearing more deportation stories tied to DUIs. Not because every first DUI equals deportation, but because a DUI is a powerful trigger event that exposes you to systems that share information, demand documentation, and can escalate a case when your status is fragile or your application is denied. And now, I need to give you the action steps. Practical, protective, real. Because fear without clarity is just torture. First, do not plead guilty to a DUI or accept a standard plea deal until you have spoken to a qualified immigration attorney or a defense attorney trained in immigration consequences. Because the specific statute, the wording of the plea, the sentence, and even whether the record shows knowledge, drugs, injury, or license status can change the immigration analysis dramatically. Remember, aggravated DUI with a knowing element has been treated as moral turpitude in immigration decisions, and you do not want to accidentally plead into the worst version of your case. Source. Second, understand that immigration has its own definition of conviction, so even deals marketed as deferred, withheld, or not a conviction can still count if there's a plea and punishment. Get that analyzed before you sign anything. Source. Third, keep documentation like your final court disposition and proof of completion of classes, probation, community service, ignition interlock, counseling, because immigration officers often demand certified records, and gaps or missing paperwork can drag your case into delays, denials, or referrals. Fourth, avoid repeat offenses like your life depends on it, because in many areas of immigration, especially good moral character for citizenship, multiple DUIs become a major presumption against you, and your future can be derailed for years. Source. Fifth, be extremely cautious about driving at all if you've had alcohol, because even one arrest within the last 5 years can become a significant alcohol-related driving incident in the medical admissibility context for some benefit adjudications, meaning the government may scrutinize your health and risk factors in a way most people never anticipate. Source. Sixth, if you have a DUI history and you're planning a major immigration filing, adjustment, naturalization, renewal, travel, do a proactive legal consult first so you are not surprised by an NTA pathway if a denial happens while you're out of status. The 2025 USCIS NTA policy explains how unfavorable decisions can intersect with removability and criminal histories, and people walking into filings blind are getting burned. Source. And now I want to end this the only honest way, with emotion, but with truth. I need you to understand what's really at stake here, because for immigrants, a DUI isn't just court dates and fines. It's your ability to keep the job that feeds your family. It's your ability to renew your status. It's your ability to travel without being pulled into secondary inspection and questioned for hours. It's your ability to stand at a citizenship interview and not feel your stomach drop when the officer asks, "Have you ever been arrested?" It's the terror of imagining your kids watching you pack a bag. The humiliation of explaining to your parents back home that you tried, you built something, and one mistake cracked the foundation. Deportation is a legal process, not an automatic button that gets pressed in every DUI case. But the risk is real. And in the tighter enforcement climate moving into 2026, the margin for error is thinner, and the consequences of, "I'll just take the plea and move on," are bigger than most people can bear. So let the urgency land where it needs to land. Not as panic, not as conspiracy, but as protection. Your future in America is worth guarding with discipline, planning, and the right legal advice before you make a decision that cannot be undone. This content is for informational and educational purposes only and does not constitute legal advice. Immigration consequences depend on individual circumstances, and laws change over time. Always consult a qualified immigration attorney regarding your specific situation.